Seller's disclosure statement laws are coming and we're getting ready for you. Empire Legal is attending the Queensland Law Society's Seller's Disclosure Roadshow this Friday, 23rd of May 2025, to get the latest on Queensland's new Seller's Disclosure scheme. Here's what you need to know now. There's a major shift coming to Queensland conveyancing, and it's one that sellers, agents and legal professionals alike need to be across. Never has it been more important to have a good property conveyancing team in your corner with these new changes. In 10 weeks' time, on the 1st of August 2025, every seller of residential property in Queensland will be required by law to provide a seller's disclosure statement, plus prescribed certificates, before the buyer signs the contract. This is part of the Property Law Act 2023 reforms, and it's the most significant change to Queensland property law in decades. At Empire Legal, we're committed to staying ahead of the curve. So this Friday, our team will be attending the Queensland Law Society's industry seminar focused entirely on the new statutory disclosure requirements. We'll be bringing you a full update afterwards, including timing, price, what's included, and how we will be supporting you and your clients every step of the way. All right, what is the seller's disclosure statement? It's a formal, legally required document that includes vital information about a property, such as easements, encumbrances, planning restrictions, statutory notices, just to name a few, which a buyer must receive and sign before executing the contract of sale. The statement must also be accompanied by prescribed certificates and searches, including, but not limited to, title search, registered plan, registered and unregistered encumbrances, unregistered leases or private agreements, written or verbal, contaminated land, pool safety, road search, QCAT search, heritage, etc. Tenancy agreements if applicable, current rates and water amounts, body corporate information, so for example, community management statements have to be attached, plus more. If this sounds like a lot, that's because it is. But don't worry, we're going to handle all of it for you. Why is this happening? Well, until now, Queensland sellers didn't have to proactively disclose certain issues with a property. It was up to the buyers to run a search and hope they didn't miss anything. Caveat emptor, buyer beware. It's been this way for a long time. This new regime flips the script, giving buyers the right to receive accurate information upfront and creating consequences if it's not done properly. If a seller fails to provide a valid and complete seller's disclosure statement before the buyer signs the contract, the buyer has the right to terminate at any time before settlement, with a full refund of deposit and other monies paid, plus the risk of losses suffered by a buyer being passed on to the seller. So it's more important than ever that the seller's disclosure statement is done right from the start. It could cost you the deal. There is also no way to contract out of this requirement, meaning buyers can't waive it and special conditions to the contrary are void. There's a few exemptions, but for the vast majority, let's just assume that you can't get out of this. Related parties and whatnot can. What does this mean for agents? So it's more important than ever to get this right from the start. As an agent, you can be authorised to prepare the seller's disclosure statement on the seller's behalf, but the timing and accuracy must be spot on. No seller's disclosure statement equals no contract. Wrong statement equals risk of termination. Outdated statement equals delay, dispute, or risk of termination. All right, George, so what happens next? Okay, so we know some other firms have already given their pricing and timeframe guidelines. We'll be attending the seminar with the Law Society, like I said, this Friday, 23rd of May, to ensure we have the latest and most practical insights straight from the experts. Shortly after that, we'll send out our pricing, what's included in the service, our turnaround times, and an easy process for agents and sellers to engage us early. We're committed to making this process seamless, efficient, and legally watertight for our clients and referral partners. If you're an agent or seller preparing to list a property from 1st of August 2025 onwards, stay tuned. The way you list, contract and sell is about to change. Keep an eye on your inbox, our full update will be coming soon. Also, stay up to date with our mini-series on seller's disclosure by following our Instagram and YouTube channels. Guys, if you have any early questions or you'd like to be able to be on a wait list for seller's disclosure statement preparation with Empire Legal as your preferred partner, please just send us an email, info@empirelegal.com.au. If your property lawyer isn't updating you about these changes, it might be time to have a think about getting yourself a new conveyancing team. This is a great change for the Queensland property industry. Let's get ready together and get it right from the start. Looking forward to sharing more with you guys soon. Ladies and gentlemen, please keep in mind that all advice is general in nature and does not constitute legal advice. This is authorised by George Souris, Empire Legal, Gold Coast, Queensland, Australia.